First cause of action, Contracts Clause violation. 161. Disney realleges and incorporates by reference all preceding paragraphs. 162. CFTOD's abrogation of the contracts violates Disney's rights under the U.S. Constitution, Article 1, Section 10, Clause 1, known as the Contracts Clause. The Contracts Clause provides that no state shall pass any law impairing the obligation of contracts. 163. The Contracts Clause prohibits local government entities from abrogating their own contracts with private entities. And there's some references there you can look at. A law that impairs a government's entity's own contracts with the private sector is especially suspect and hence subject to heightened judicial scrutiny. 164. The rights protected by the Contracts Clause are familiar to Florida law. Indeed, the Florida Supreme Court has pronounced the right to contract to be one of the most sacrosanct rights guaranteed by our fundamental law. 165. The legislative declaration violates that most sacrosanct right and thus deprives Disney of its rights under the Contracts Clause. By declaring the contracts void, the legislative declaration purports to rescind Disney's rights and protections under the contracts and to relieve CFTOD of any obligation to comply with its obligations under the contracts or to pay damages for any breaches. 161. The substantial, indeed total, impairment of Disney's contract rights was not necessary to serve an important government interest, as required to survive Contracts Clause scrutiny. As alleged in this complaint, the contracts were abrogated as part of an explicit campaign of official government retaliation against Disney for expressing a viewpoint the governor and legislature disagreed with. That objective is the opposite of important. It is categorically impermissible. 167. Any other asserted reasons for abrogating the contracts are pretextual. RCID was fully empowered to enter into the contracts. Special districts commonly enter into contracts with developers, including special districts with governing structures defined by land ownership. And the law establishing CFTOD expressly provides that all pre-existing RCID contracts remain fully enforceable. 168. Just as in other long-term development contracts in other special districts, the contracts here involve land use rights and obligations, not sovereign or police powers, that special districts are legally barred from delegating. The contracts establish Disney's rights concerning use of its own property and as expressly authorized by RCID's charter, restrict CFTOD from using its own property for non-public purposes that interfere with Disney's development of its property. Reedy Creek Enabling Act 9, authorizing RCID to subject its land to encumbrance. In exchange, the contracts restrict Disney's use of its own property to specify development purposes and obligate Disney to convey its property at fair market value when needed for public purposes. 169. CFTOD has identified no reason or need to treat the contracts differently from long-term development agreements entered into by developers in other special districts. 170. Even if CFTOD could articulate an important interest uniquely implicated by the contracts that is not implicated by other special district development contracts, CFTOD cannot show that complete abrogation of the contracts is necessary to serve any such interest. Under the Contracts Clause, the government is not free to impose a drastic impairment when an evident and more moderate course would serve its purpose equally well. An impairment of a contract thus is prohibited if a less drastic modification would have permitted the government to advance its purpose while allowing the contract to remain in place. CFTOD has not identified any important government interest justifying its abrogation at all, much less an important interest that cannot be satisfied by modifying some provision or provisions of the contracts. 171. CFTOD's decision to abrogate the contracts completely, rather than pursue modification of whatever provisions CFTOD claims to be unlawful, underscores its motivation to punish Disney for its political speech rather than to operate as a good faith counterparty in the continued development of the district. 172. Disney is entitled to a declaration that abrogation of the contracts violates Disney's rights under the Contracts Clause and that the contracts remain in effect and enforceable. Disney is further entitled to an order enjoining defendants from enforcing the legislative declaration. Second cause of action, Takings Clause violation. 173. Disney realleges and incorporates by reference all preceding paragraphs. 174. The legislative declaration takes Disney's property without providing just compensation, in violation of the Takings Clause of the Fifth Amendment to U.S. Constitution. The Takings Clause provides, nor shall private property be taken for public use without just compensation. 175. Contract rights are a form of property, and as such may be taken for public purpose, provided that just compensation is paid. And there's some references as well. Not all contracts rights necessarily qualify as property under the Takings Clause, and thus the fact that legislation disregards or destroys existing contractual rights does not always transform the regulation into an illegal taking. But when a law overrides substantive contract rights and specific real property, the clause's protections apply. Again, there's more references to previous lawsuits. 176. The contracts secure valuable substantive rights in specific property, i.e. the parcels explicitly identified in the contracts. The development agreement, for example, grants Disney various long-term rights in the use and development of its land, consistent with a comprehensive plan found compliant by Florida law by Desantis administration. The restrictive covenants likewise protect Disney's rights to develop its land by limiting CFTOD's ability to use its adjacent lands in ways that damage or destroy Disney's development rights. When the government uses its own property in such a way that it destroys private property, it has taken that property. And that's a quote from Justice Scalia, actually. The legislative declaration expressly deprives Disney of those valuable rights in private property without making any payment to Disney in exchange for the deprivation. The legislative declaration thus takes Disney's property without just compensation. 177. Disney is entitled to a declaration that the taking of Disney property rights without payment of just compensation violates the Takings Clause, and that the property rights set forth in the contracts remain in effect and enforceable. Disney is further entitled to an order enjoining defendants from enforcing the legislative declaration. Third cause of action, due process clause violation. 178. Disney realleges and incorporates by reference all preceding paragraphs. 179. The legislative declaration abrogates the contracts without any rational basis and for only impermissible reasons, in violation of the Due Process Clause of the 14th Amendment to the U.S. Constitution. The Due Process Clause provides no person shall be deprived of life, liberty, or property without due process of law. 180. The Due Process Clause forbids any state or local entity from adopting any arbitrary and irrational legislative act affecting a person's state-created rights, including property interests. In other words, states must demonstrate that they are violating private interests only as necessary to promote state interests. 181. CFTOD cannot make that showing here. As alleged in this complaint, the legislative declaration purporting to abrogate the contracts was not enacted for any legitimate state interests. It was instead enacted to further an official state campaign of retaliation against Disney for expressing a viewpoint that Governor Desantis and his legislative allies disagree with. 182. Further, CFTOD does not and cannot demonstrate that complete abrogation of the contracts is reasonably necessary to advance any state interest that could be legitimate. CFTOD cannot show that the contracts are dissimilar in character to contracts between other developers and special districts to fix long-term development rights and obligations. Nor can CFTOD show that the contracts contradict any aspect of comprehensive plan found compliant by the state. CFTOD thus cannot identify a non-arbitrary, rational basis for singling out and voiding the contracts. 183. Disney is entitled to a declaration that the arbitrary and irrational voiding of the contracts violates the Due Process Clause, and that the contracts remain in effect and enforceable.